Welcome to the PI show. My name's Harry Nowicki. I'm a common law lawyer and I'm with a colleague, Tony Carbone, who's also a common law lawyer. And we're here to talk about personal injuries and the common law.
Good evening, Harry.
Welcome, Tony. Now, the reason why we raise issues about particular cases is that the judges make law in this area. The judges decide generally on how these matters are put and run, and the common law is in effect judge-made law. It's not made by Parliament, it's made by the judges, and in our system in Victoria it's by juries as well. 6 people selected at random make decisions about people's lives in the personal injury area. Now, the first case we've got is a 27-year-old film making person, and this is of great interest to the support staff here because they all are freelance agents making and producing films. And in August 1997, the person had finished making a film, went to a hotel with her mates and tripped and fell on some steps at the hotel and damaged her right knee. Now, in a few years later, she issued a claim in court. She sued the hotel. Has she got a claim?
Yes, she has. Firstly, she's got to prove negligence, and I think the facts of that case were pretty strong because there was poor lighting, and I think there was an issue about a defective step. So on liability, she was pretty good. Okay,
so she proved that the hotel had poor lighting and was negligent as what's called an occupier. Occupiers should provide a safe area where people can go and walk, and she fell down a step and injured her right knee. Very severe injury, it struck me, for a 27-year-old.
Yeah, it was a really nasty injury because she had surgery on it in the first instance and she was out of work for some period of time. So she had a loss of earnings and, you know, reasonably extensive medical expenses.
Now, what happened ultimately was the matter went to trial before a jury, 6 people. She had lawyers representing her. She put her case in this way. She said, look, after 97 she had one child, then in 2001 she was expecting a second child at the date of trial, 2 children. And she said, because of my knee, I've struggled to work since 98, 99, and in the future, when I get back to work, I'll struggle, and I've lost a lot of income in the future. Now, the jury was argued extensively. Ultimately, the jury accepted the submissions of the barrister and awarded her $232,000 in damages, pain and suffering, and financial loss, and the jury said she was 20% to blame for the accident. So 20% came off $232,000. She got approximately, after interest, $190,000. Was that a fair result?
Well, she probably got about $120,000 for pain and suffering, which, yeah, it's reasonably fair, although she was only 27 years of age at the date of incident. I would have thought she could have got more because there was evidence that she may need a total knee reconstruction or replacement in 20 years' time. And she got her past loss of earnings, which wasn't big. It was about 7,000 or 8,000, 12 weeks I think it was. And she also got her medical expenses to date. Plus there was an allowance made for the cost of future surgery. So the court accepted that, or the jury accepted that she's going to have a knee replacement in the future.
But knee replacement in the future, it may not ever happen.
No, that's right, it may never happen.
Why should the court award someone some compensation for some event that will never happen?
Well, these cases are decided on the balance. On the balance of probabilities, will she need a knee replacement? There was a couple of doctors that said she will, including her surgeon. She's got arthritis.
One doctor said she made a reasonable recovery. She doesn't need a knee operation.
Well, Harry, it's all a matter of opinion, and we know from past experience that a lot of these people that sustain these sorts of injuries in the future, because she's still only relatively young, chances are she'll come to a knee replacement. As to when, no one knows.
All right, well, how did the court arrive, or the jury arrive? I think the barrister told the jury that they should adopt what he called a broad brush approach, and he put to the jury, he thought the future financial loss for this person, she's earning about $740 plus about $50 of super at the time of the accident. The barrister said to the jury, I think in the future she's going to lose approximately $100,000 financially. The barrister was criticised for that because the defendant said, you've got no basis on which to say she's going to lose any money whatsoever.
I think he did a fantastic job because, you know, you're guessing into the future, but one of the key elements was, you know, a little passage I want to read where it says, on the evidence, taken in size from her point of view, if the injury renders it likely that lead to progressive degeneration, which may at times extends unable to be calculated with precision, may impede or destroy her work in future, then in those circumstances she's entitled to the loss of income. I think he did a great job. Really, I mean, that figure of 100,000, he plucked it out of the air, and the jury bought it.
Well, but the other side, the defendant for the insurer of the hotel, said to the court, the barrister can't pluck a figure out of the air. It's not right. It's just guesswork, and she's in effect, unless you can quantify an economic loss properly, you're not entitled to any future economic loss. And that's what he told the judge, and eventually went to a court of appeal.
Well, the majority of cases are decided on the basis that you're losing $100, $200 a week, or $400 a week, or $1,000, and then we use what they call actuarial tables, which are tables...
But you couldn't use this in this case. You had no figure to work with.
The tables did not work in this case. They were thrown out the door, and all they did was it was a rough guess. At a guess, you know, she was young.
The defendant would say it's Tatslotto, you're just plucking a figure out of the air, you just guesswork, and I think their position is negative, and they just simply try and, their job is to try and reduce what someone gets, you know, which is fair compensation under common law. But I agree with you, the barrister plaintiff did a great job, and the jury accepted that she was going to have a knee reconstruction, she was going to be out of work, and accepted she was going to come back into the workforce. So I think it was a reasonable result, went to the Court of Appeal, and the Court of Appeal dismissed the appeal by the insurer. I think that's all we've got time for initially. We're coming back, see you after the break.